In this video, I want to give you an introduction to trademarks and registration. I guess from the start, some of you may wonder why I raised the topic of trademarks in a technology law class. The most obvious answer is that trademarks are clearly important to a number of tech companies. I'm sure Apple, Amazon, and Google would not question my decision to address the basics of trademarks here. In addition, you need to understand the roles that trademarks play when you venture into the internet space or choose domain names. Also, trademarks round out the discussion of intellectual property, which is the main focus of this course. And finally, I've got to tell you, when entrepreneurs, including our entrepreneurship students, talk to me regarding their business plans, the number one question that they have almost invariably will be about their trademark options. So yes, I think it's worth spending a little time on this topic. Having said that, let's be clear that the purposes of trademarks are very different than the other elements of intellectual property. We've already talked about patents, trade secrets, and copyrights, and all of them are intended to stimulate and reward investments in creative ventures, product innovations, and new information. The purposes of trademarks, on the other hand, are simply to help you find the products you want, or, to say it more precisely, to identify the sources of the products or services that are available in the marketplace. Here's a simple example. Since I'm in San Luis Obispo, which is wine country, let's just say that I make a pretty high quality wine that people like. For this reason, I put an identifier on the bottle so that people can easily find it among the hundreds of other wine offerings at the store. That identifier, by the way, is the word Bluebird. In a world of totally free and perfect competition, potential competitors can copy anything about my product that is not protected by a patent or copyright. So, Bluebird can't meet the standards for either of these, which means that it is open season for others to use the name on their wine labels. Now, there are a lot of negatives that may result when this happens. The first is that this competitor may be really unethical and hope to confuse individuals who want my excellent wine by tricking them with the name. You know, they see the wine and think, Bluebird. I hear that's really good and worth $30 per bottle. So they buy it, bring it home, and when they try it, it's horrible. Just really cheap rot gut. What this competitor has just done is sold what is basically a $2 bottle of wine for $30 and made a very tidy profit. And he did this by fooling people about the source of the product. They thought it came from me, the source of the real Bluebird, but it did not. When this happens, we say that the customer palmed off his inferior product for the real thing by creating confusion as to its source. And so I hope you have this feeling that what this company is doing, trying to trick customers into buying his products by mistake, is unethical. And that is one reason for trademark laws, to deter this kind of unethical behavior, which free competition would otherwise allow. Trademarks solve the problem by preventing unscrupulous individuals who know that I use Bluebird as an identifier from tricking people by attaching a confusingly similar name on their product. Beyond the ethical justifications, trademarks also provide overall social benefits. For one, if I know that customers can readily find my wine, then it makes sense to keep investing in quality harvests. On the other hand, if they are fooled by unscrupulous tricksters, then the public will soon question my quality control. If you bought a bottle of Bluebird and it was awful, you might question the integrity of my company. You certainly would hesitate before paying $30 again for it. And given the confusion, why should I even try to make a great wine, since I will have a hard time letting people know where their bottle of Bluebird really came from? However, If I have exclusive rights to Bluebird, then my customers will enjoy a consistently good experience and I can expect to retain their loyalty. This is what I mean by saying that trademarks protect investments in goodwill. The other benefit from trademarks is that they simply make shopping easier for the customer. If you know about Bluebird and find a bottle with that name on it, then boom, buy it. End of story. Without trademarks, seeing Bluebird might not be enough because cheap imitators may be trying to trick you. So you may have to take other steps to assure where it came from. We call these other steps search costs, and trademarks serve to reduce them and thereby make shopping more efficient. Based on these underlying principles, I want to first give you a few key concepts about federal trademark protection, and then we'll go over how registration ties into all of this. The first important attribute of a trademark is that it has to be a distinctive identifier. The distinctive part means that your identifier has to be something that people can use to distinguish your product from others on the market. To do this, it can't be confusingly similar to something that another company already uses as its identifier. Thus, if a company already sells a wine called Bluebird, then our name would not serve to distinguish us from that other winery. But what if another company calls their wine Boo-Bird or Bluebeard? These names are not identical to Bluebird, but they may be so similar that consumers who want those products might be confused and buy ours by mistake. This gets into an evaluation regarding the likelihood of confusion, which we will look at shortly. The trademark also has to be something that consumers actually use to identify source. Of course, we often think of trademarks as names, but many other attributes can serve identification functions. For instance, they can also be symbols, type styles, drawings, even product attributes, as long as those features are perceived as something that is added to the basic product and not part of the product itself. Similarly, if we choose a name, it has to be perceived as separate from the generic name for the product. For instance, we might use the word wine on our bottle, but consumers would see this as identifying the type of product and not the source of the product. Thus, we can sell Bluebird wine where Bluebird identifies the source and wine indicates the product. And so we can get a trademark for Bluebird, but not wine. Have companies tried to protect generic names as trademarks? The answer is yes. For instance, there has been litigation about rights to generic terms such as cola and shuttle. There even has been controversy about whether the word Windows is generic for computer programs that use Windows as part of the interface. This came up when Microsoft sued another company for naming its operating system Lindows, which Microsoft claimed was confusingly similar to its trademark. Lindows argued that Microsoft could not have exclusive rights to Windows because it was generic for the type of interface. Actually, the judge seemed intrigued by the argument, so intrigued that Microsoft soon backed off and reached a settlement. A similar dispute also arose when Apple sued Amazon for using the single squished word App Store for its online application site. Apple claimed the term was confusingly similar to its trademark for App Store, which appears as two separate words. Amazon responded that App Store was generic for a location that sells applications, and thus the phrase did not identify Apple or any other company as the operator. Okay, you get the idea. A generic term for a product cannot serve as an identifier for the source of that product. Similar kinds of considerations also apply to phrases that describe a product. For instance, if I call my wine organic soils, people will at first think that I'm using the term to describe the growing conditions and not to indicate source. However, if I exclusively use that phrase for a long period of time, consumers may begin to understand that all organic soils wines come from the same place, and then may actually become confused if a competitor starts using the same phrase. For this reason, a company cannot initially get trademark rights for a descriptive term or phrase, but over time, it may acquire those rights if it can demonstrate that consumers use it to identify an exclusive seller. In trademark circles, we call this learned identification function secondary meaning. The primary meaning is the description, and the identifying characteristic that arises over time is the secondary meaning. In this regard, think honey baked, soft soap, rollerblade, or instant breakfast. All of these are descriptive, but have trademark rights because over time, consumers came to understand that the names identified source. So, just to throw you a curve, what would you say if Subway wanted exclusive rights to footlong for sandwiches? Because believe me, they do. Is the word generic? Is it descriptive? If the latter, does it have secondary meaning? Or putting this another way, when you randomly walk into a deli and see a footlong on the menu board, do you believe that the shop is affiliated with Subway? Well, all I can tell you is that Subway has not been successful to date. This is probably a good time for me to mention the spectrum of trademark protection. At the bottom end are generic words, which can never be legitimately protected as trademarks. Next are descriptive words that can't be protected at first, but over time may serve as trademarks if they attain secondary meaning. Then there are suggestive words that require thought and imagination to recognize the associated product. An example might be Orange Crush for a soda. These are suitable for trademarks right out of the gate. And the same conclusion for what are called fanciful marks. Those are the ones that are totally unrelated to the product or service. Exxon would be a good example of this. Okay, another criterion for a trademark is that it should not give a firm what we call non-reputational advantages. Trademarks are intended to preserve a company's reputation by allowing customers to easily find its products, so that's an appropriate function. But it is possible for firms to try to claim attributes as identifiers that actually do more than simply point to the source and provide competitive advantages in the market. When might this happen? Well, it can kind of happen with words. For instance, if we allowed a company to monopolize a generic word, that might be competitively unfair to other companies in the industry. So that's just another reason to not allow trademarks for generic words and symbols. But where this really comes up is with product designs, which is a topic that I find fascinating, but I have decided to basically skip it in this course. But I'll give you a few examples of what I'm talking about here, just to give you a taste of what all this means. Some of you may be familiar with the traditional Bose speaker, which had a distinctive five-sided shape, which was easy to spot. Bose claimed that the shape served as an identifier, and in fact, it probably did, since consumers did assume from the shape that the speaker came from Bose. However, Bose could not protect the shape as a trademark because it actually contributed to the reflective sonic capabilities of the speaker. In other words, the shape did more than simply identify source. It actually was an important component for the operation of the device. So there are a zillion cases like this. Here's one that reached the Supreme Court. A company had a utility patent on a two-spring design for a road sign that allowed the sign to bend when it was windy, but not break. Due to the patent, it was the only company to use that design for a long period of time. So people associated the two springs with that source. For this reason, when the patent expired, the company sought trademark protection. But the Supreme Court said no, because the design was an important feature that made the sign work as customers desired. In other words, it did more than simply identify source. Here's another one. You all probably know that John Deere tractors are green. But when the company sought trademark rights to the color for farm equipment, a court refused, finding that farmers preferred to own green tractors because the color blends in better in their fields. Thus, a trademark for green on tractors was seen as potentially providing Deere with a non-reputational advantage. Having said that, Deere is the only company that can sell green tractors with yellow wheels, since the combination does not provide an advantage. Oh, and here's one more, just to give you an idea of how far this can go. You may be familiar with a bar called Hooters, and that its waitresses wear orange running shorts and white tank tops. Well, Hooters became upset with a bar in Texas that had its female employees also wear running shorts and tank tops, but they were black. Hooters claimed that whenever customers see shorts and tank tops, they think of Hooters, no matter what colors are on the outfits. The judge denied the trademark claim, stating that running shorts and tank tops attracted male clients, and so giving Hooters exclusive rights would give it a competitive advantage. Thus, regarding trademarks, the outfit with orange and white? Yes. The outfit, no matter what the color? No. All right, so let's get to the next item, which is that trademark rights are typically tied to use in the United States. We'll soon see that in some countries, you can obtain trademark rights simply by being the first to register the name or symbol in that nation. You don't have to use the mark in that country. You don't even have to indicate an intent to use it. The United States is different in this regard, and for the most part, you will need to use the trademark within the United States to lock down a trademark. Thus, the usual pattern is that I use a trademark on goods or services in the United States, and then somebody who knows about that use puts a similar mark on their wares, which leads to confusion as to source. So, I'm going to cover this in more detail when we get to registration and the role that it plays regarding notice. And we will see that you can now reserve a trademark through what is called an intent to use application. But you will still need to use it to actually get the trademark. And thus, with a couple exceptions, I will stick to the concept that use, and indeed interstate use, is required in the United States in order to get a trademark. What are the exceptions? Well, one exception involves foreigners who have registrations abroad. I don't care that you know about this, but since this is being recorded, I'll mention it in a few minutes when we address registration. The other exception, which I have listed here, regards foreign companies that don't operate in the United States, but their brand is so well known within the US that consumers in this country would be confused if other companies use the same mark. What do I mean? Well, anyone who has spent time in London probably knows about Harrods department store. I actually don't know if they have opened a store in the US, but assuming that they have not, they may still have rights against another company that may want to name their store Harrods because the London store is so well known to a large number of shoppers here in the States. On the other hand, if a company operates overseas but is not well known in the United States, then it cannot prevent another firm from using the mark in the US, nor prevent another company from registering the name here. As an example, there is the saga with Fashion Cafe. In a nutshell, an Italian company ran a restaurant with a fashion model theme in Italy. A US citizen named Booty visited the restaurant in Italy and thought it was a great idea. Booty opened a similar kind of restaurant in Florida, which he called Fashion Cafe, and he had plans to expand into New York and other markets. The Italian company sued, claiming that it had trademark rights to the name in the US, and that Booty was infringing its mark, among other things. Well, Booty may seem like an unscrupulous guy, but he wins because Fashion Cafe had not yet been used in the US, nor was it well known in US circles. In addition, since Booty was the first to use the Fashion Cafe mark in the United States, he ended up owning the US trademark rights, and he was even able to get a federal registration for the name. Once you have a protected trademark, then you have rights against those who have reasonable awareness of your mark and create a likelihood of confusion or dilution. I already mentioned how trademarks are somewhat founded on principles of ethics and deterring palming off. And palming off does require some intent or knowledge that use of a mark might cause consumer confusion. So I want to follow up briefly here about how knowledge plays into trademark policies. Let's just take as an example a surprisingly popular coffee shop here called Scout. I also would like to assume that there are a couple of other Scout coffee shops in a few other cities in the US. For instance, let's say there is one in Austin, Texas. By the way, the owner there landed on the name Scout because she was a Girl Scouts troop leader and loved her coffee before meeting the campers in the morning. There's also a shop in Eugene that the proprietor called Scout after his son. So you see how this might happen by chance. Okay, back to the Austin store. That owner is not an evil person, right? She's not trying to palm off her coffee to recent Cal Poly grads or others familiar with a SLO store. She's never even heard of Scout in SLO. In fact, she probably has never even heard of San Luis Obispo. She just innocently selected the name and opened her shop. And let's say she becomes successful and starts to open other locations in around Austin, and then maybe expands to other cities in Texas. So here we go. Slow Scout builds awareness of its brand in California, while Austin Scout does the same in Texas. And the Eugene Scout may do the same up in Oregon. Well, inevitably, the expansion activities are going to meet in the same places. Maybe SLO Scout recognizes that its formula works in college towns, and so eyes to open a franchise in Austin, near the UT campus. Now, here's the problem. Slow Scout obviously wants to call its new store Scout in Austin, but Austin Scout is already established there. And clearly, if there are two shops called Scout in Austin, people will naturally be confused and probably believe that they are run by the same outfit. So someone's got to give. The problem is that there is no true bad person here. Slow Scout was the first to use the name in the country, but Austin Scout never knew about it and built brand recognition for her stores in that area of Texas. If it were my call under these circumstances, I would vote for Austin Scout to retain the name. She's the one who built the reputation in Austin, and Slow Scout is the outsider that will confuse her established customer base by coming in with the same name. So that is the way trademark policy would likely handle this problem. Also, note that if Austin Scout wanted to move into San Luis Obispo, Slow Scout should be able to retain the name there. This means that it is very possible for different companies to own trademark rights to the same name for the same kinds of products in different areas of the country. In this way, trademarks can be viewed as being regional in scope. Okay, let's change the facts a little bit. Suppose a visitor from Phoenix meets friends at Slow Scout and thinks, wow, what a great outfit. This is going to take off. I like the name. I like the layout. I like it all. And I'm going to do the same thing in Phoenix. And the more people broadly talk about Slow Scout, the more I will benefit in Phoenix, because people may assume we are affiliated. Sure, my coffee's not great, but the name may draw them in, especially when Slow Scout starts expanding in my direction. So, this is a little bit different because the operator of Phoenix Scout is not so innocent. He knows that Scout is being used as a trademark for coffee in SLO and adopts the name anyway. So now, if consumers become confused, I'm inclined to hold him responsible since he was aware of the possibility. And frankly, that's how things would unfold. However, I have to tell you that as long as consumers in Phoenix don't readily know about Slow Scout, there would be no confusion from allowing Phoenix Scout to keep that name. But once Slow Scout wants to move into the Phoenix market, confusion then might result. And I'd say then that it would be fair to make the Phoenix Scout change its name. And confusion may arise earlier. For instance, if Slow Scout had a website and started selling its cookies to customers in Phoenix, this might be enough. It all depends on the circumstances. The bottom line is that trademark rights in the US depend on others reasonably knowing about your use and then adopting a confusingly similar mark. And I've mentioned how this may result in different companies owning rights to the same mark in different areas, even within the United States. But I just want to point out here that trademarks are regional in the international space as well, so that a company with rights in the United States may not own those rights in other nations. Just think back to Fashion Cafe, which had different owners in Italy and the United States. And just to give you another example for the moment, I want you to check out this beer from Czechoslovakia. Yes, it's Budweiser. This one is made by Budvar, and it was the first in the world to sell Budweiser. Budvar also has trademark rights, at least in Czechoslovakia, if not elsewhere. Anheuser-Busch adopted the name later, and it owns the trademark in the United States, and I'm sure in many other countries. Anyway, I could do the same with zillions of products. Okay, so we've now covered the key concepts underlying trademarks, and now I want to move on to federal registration. And let me begin by telling you that there are definitely good reasons to consider registering a trademark. But strictly speaking, registration is not required to obtain or enforce trademark rights in the United States. As long as you use a mark that people associate with your product or services, then you can prevent other companies from knowingly confusing consumers. So then, why should you register? The most important reason is that the registration informs everybody in the United States that you are using the mark for particular kinds of activities. And so anyone who adopts a name does so with knowledge. What date counts? The date of filing the application, assuming the PTO ultimately registers the mark. And why does it matter? Well, just think back to the example of Slow Scout moving into Austin. If Austin Scout did not know about the Slow Scout's previous use, then Slow Scout has to change its name when it decides to enter the Austin market. However, if Slow Scout had a federal registration, then it will be assumed that Austin Scout adopted its names with knowledge, and so Austin Scout will have to make the change. We will presume that the owner of Austin Scout had knowledge based on the registration, even if she never actually looked at the registration files, which is very possible. In the trademark community, we say that the registration provides constructive notice of use at the time of filing the trademark application. So, what does registration do? It gives a company priority over others to retain the name anywhere in the United States whenever the circumstances might lead to customer confusion. And again, the knowledge stems from the application filing date. There are a few other benefits from federal registration that may turn out to be useful. One is that you can record a registered trademark with Customs and Border Protection, which can help with blocking imports of infringing goods. Another plus is that you are eligible for enhanced remedies for trademark counterfeiting if your mark is registered. Counterfeiting is the most egregious form of infringement where someone essentially duplicates your mark on the same goods or services. And finally, you have a better chance winning a case for dilution when your mark is registered. We will address dilution a little later, probably in the class session. The concepts underlying registration derive from the general principles we just reviewed. Thus, a mark is only suitable for registration if it serves to identify the source of the associated goods or services. For this reason, the PTO is not supposed to register a mark that is generic, and if it does so, it has made a mistake. Likewise, it should not register a descriptive term unless the applicant can prove secondary meaning, or in other words, that the consuming public has come to connect the term with the source. Often this is done with surveys that demonstrate consumer understanding or by evaluating ad budgets. In addition, if you can show that you are the only company to have used the descriptive term for 5 years, then that will be strong evidence of secondary meaning. A mark also can't be registered unless it serves to distinguish your product and prevent confusion in the market. To this end, a mark is not eligible for registration if it is confusingly similar to one that is already being used or has been registered by someone else in the United States. Okay, a couple of things about this. I already emphasized that the previous use or registration has to be in the United States. This explains the Fashion Cafe situation. The Italian restaurant opened in 1987, and the mark was registered in Italy in 1988. Nevertheless, Booty opened a fashion cafe in Miami in 1993 and registered Fashion Cafe with the PTO in 1994. Soon thereafter, the Italian company was considering opening a restaurant in the US and recognized that there might be confusion because the two companies would be operating with the same mark. So litigation ensued with the Italian company challenging Booty's use of the mark and the federal registration. And as I mentioned, the Italian company lost because it had not used or registered the mark in the US before Booty opened his cafe. For this reason, Booty got to keep the registration, despite knowing about the previous Italian operations. However, remember that there is an exception to this rule when the foreign mark is well known to US consumers. In this event, the foreign firm may be able to block the registration, despite the absence of use in the United States. This principle is based on provisions in international treaties, And thus US firms that are famous overseas have the same ability to block registrations there by others. We'll look at this further when we get to international trademark considerations. And we'll see that McDonald's and Kmart, among others, have benefited from these provisions. Okay, so that's the use or registration in the United States part. The other component is that the mark can't be confusingly similar to the previous mark. So if I asked the PTO to register Bluebird for wine, would it matter if there were already a wine on the market called Bluebeard, or Greenbird, or Blowhard? The answer is maybe, and it will depend on how one addresses likelihood of confusion. So I want to go over this in the class session because the evaluation of confusing similarity is central to trademark law. It comes up here with registration because a mark can't be legitimately registered if it is confusingly similar to a prior use or registration. But the standards are also relevant on the flip side when you have trademark rights. For instance, if you sue for infringement, you will have to demonstrate that the disputed use may cause a likelihood of confusion among consumers. Another feature of US trademark law is that use is required in interstate commerce within the United States prior to registration. One way to satisfy this requirement is to use the mark prior to filing the trademark application. In fact, until somewhat recently, you had to do this, which often led to hardships for entrepreneurs. Consider this. Suppose I want to call my wine Bluebird, but I'm not sure if the PTO will register it. Maybe the examiner will think that the name is descriptive or confusingly similar to a previous registration. However, before I could even apply, I would have to finance a marketing campaign and sell bottles of Bluebird. So that's a big risk because the PTO might then reject the application, which means I basically wasted the time and investment on rolling out Bluebird. Okay, so you can still meet the use requirement by demonstrating use before you file. But there now is another method which allows you to learn if the PTO is willing to register a mark, assuming you use it relatively soon after the office tells you. This is called an intent to use application, and I highly recommend that you consider it and discuss it with your attorney. Here, in a nutshell, is how it works. For instance, if I'm thinking about Bluebird for wine, I could file an application based on my good faith intent to use it. The PTO then reviews the application in the same way that it would review a normal one based on actual use. So they will review if the word is generic or descriptive and whether it is confusingly similar to previous registrations or uses. Assuming the name overcomes the typical registration procedures, the PTO will issue a notice of allowance. A notice of allowance is not yet a registration. Rather, it informs me that if I now use the Bluebird mark within a specified time limit, then I will get the registration. That time limit is 1 year, but it can be extended to up to 3 years for good cause. So let's say I have to use it within 3 years, and if I don't, then my application will be abandoned. The beauty of this process is that if you follow through by using the mark appropriately after getting the notice of allowance, then the filing date for the intent to use application will count as your constructive notice date that applies for trademark priority. On the other hand, if you don't use the mark in time and abandon the application, then that will open the door for others to claim the mark. So, even with intent to use applications, you ultimately have to use the mark in the United States to register it and gain the benefits from registration. However, I noted earlier that there is an exception to the requirement about use in the US. And so here it is. Due to an international treaty, a foreigner that has a registration for a mark in their native country can get a registration in the US even without using it here, assuming that they satisfy the other requirements to obtain the registration. That is, they still will have to prove that the mark identifies source and is not confusingly similar to other US marks to get approval. But use in the United States is not required to get the registration. Why didn't this apply to Fashion Cafe? Because the Italian company did not file for its US registration until after Booty had opened his store and filed with the USPTO. Had the Italian owner filed earlier in the United States, the result may have been different. Also, I guess I should mention this. Strictly speaking, the law requires that the trademark owner use the mark in the US to maintain the registration, or it could be canceled. Thus, at the end of the day, use will be necessary, even for foreign nationals who registered under this exception. Do I care that you know about intent to use applications? Absolutely. Do I want you to know the nuances that allow foreign nationals to possibly get a US registration based on their hometown registration? No, not really. I just covered it because you may bump into it someday and wonder what's going on. Okay, I just want to round out this introduction by alerting you to a couple other possible bumps in the registration road and how you could potentially lose a registration after you have successfully obtained it. So let's just say for simplicity that I've sold Bluebird wine in a couple states and apply for federal trademark registration. The examiner reviews the application and determines that Bluebird is not generic or descriptive for wine, and so it is capable of identifying source. For registration to be proper, Bluebird also must not be confusingly similar to marks that have already been used or registered. In this regard, the examiner will only compare Bluebird to previously registered marks to make her determination. So let's say she does this and determines that nothing has yet been registered that stands in the way. But what about companies that may be using a confusingly similar term on wine, but decided not to register their marks? What does the PTO do to uncover these potential uses? What it does is publish a notice in various places. The website is one source, and basically say that they have reviewed Bluebird and they are prepared to register it unless somebody steps up within 30 days and opposes the decision. So this is where others who have used similar trademarks can alert the agency. It's also an opportunity for competitors to challenge decisions by the examiner, such as whether the mark is generic or descriptive. Usually there is no response, and then the trademark will be routinely registered within a few months thereafter. Sometimes, though, companies will file oppositions, which can lead to legal proceedings before a special panel called the Trademark Trial and Appeal Board. One example that I previously mentioned involved Apple's application for App Store, as used with an online computer software distribution platform. The PTO reviewed the application and determined that App Store was sufficiently distinctive to be registered. In the examiner's opinion, the mark was descriptive but had attained secondary meaning. It also was not confusingly similar to previously registered trademarks. The PTO published its determination on January 5th, 2010, and Microsoft opposed the registration, claiming that App Store was generic, or too descriptive for a store that sold software apps. This then led to a formal hearing before the Trademark Trial and Appeal Board. While this opposition proceeding was going on, Amazon began to use the term App Store to identify its online software marketplace for Android applications. What's the difference in the marks? Amazon squeezed the words together while Apple separated the two words. Apple then sued Amazon for trademark infringement. Yes, it doesn't yet have a registration due to Microsoft's opposition, but it doesn't need one. Instead, it argued that it had been using the name for years and everybody, including Amazon, knew about it. Thus, it alleged that Amazon was one of those bad companies that was purposely attempting to confuse the public. Okay, well, Apple dropped its lawsuit against Amazon, perhaps because things weren't going all that well in the proceedings. Thus, Amazon has continued to use its spelling of App Store squished together. Microsoft also eventually withdrew its opposition to the registration in 2015, and Apple then finally got its registration for App Store. All right, that's a long-winded example of an opposition, but just recognize that your trademark application is reviewed by the PTO examiner and then must survive a possible opposition. At that point, perhaps you can momentarily pop the champagne cork, but you can't totally relax because your registration is still subject to possible cancellation. Why would this happen? Well, maybe someone who used Bluebird previously for wine did not see the PTO's notice that it was about to register Bluebird and only became aware later. Or perhaps I threatened another firm with a trademark suit, and so they said, back off, or we will convince the PTO that it made a mistake by granting you registration in the first place. Anyway, what they're going to do is file a petition for a cancellation of the registration with a Trademark Trial and Appeal Board. The process is very similar to an opposition, except that the burden of proof may be higher to convince the board to cancel a mark. One situation you may have heard about involved the trademark registration for the Washington Redskins. I didn't mention this, but a controversial provision of the Lanham Act does not allow registration of scandalous or disparaging marks. Several Native Americans petitioned to cancel the Redskins mark, saying that the name was disparaging. They actually proved their point, but the Supreme Court ruled that the disparagement limitation violated the free speech rights of the team to identify itself as the Redskins. Thus, the team ultimately won this battle, but of course it ultimately lost in the war of public opinion. Okay, one thing about cancellations is that in most situations, you only have 5 years to raise objections. So if you want to argue that you were a previous user, or that the mark is descriptive without secondary meaning, you have to do that within 5 years of registration, or you're out of luck. Thus, if you are a cautious individual, you may wait until that 5-year mark to actually drink that champagne. However, there are some objections that you can raise even after the 5-year mark. The most important is that you can always claim that a mark is generic. You might, for instance, claim that the PTO made a mistake and registered a mark that was generic at the time of the application. Microsoft faced this possibility regarding its registration for Windows. Perhaps more notably, though, competitors might petition for cancellation on the grounds that a mark has become the generic term for a product or service, a result called genericide. This often happens because of the way trademark names are used in marketing and how customers then use the term. So be aware that when the public begins to casually use your trademark name to refer to the product class, then your mark may be in jeopardy. Examples of trademarks that have been lost to genericide include trampoline, escalator, Monopoly for the board game, aspirin, and thermos. Several brands are very worried that consumers are too often misusing their trademarks by using it to identify the class of products. When does this happen? Well, have you ever asked for a Coke when you meant that you wanted a cola? How about a Kleenex when any facial tissue would do? Or Xerox a copy? Or stick something together with Velcro? Or Google an answer? Or put on a Band-Aid? Yes, all of these are trademarks, and the firms have had reason to worry about the generic uses of these terms. What do they do about it? Well, they take steps to make sure that the public understands that the names refer to brands of the products and not to the products themselves. One common approach is to introduce ad campaigns that clearly indicate that the jeopardized trademark is one source of a distinct product class. In this way, the ad will make it clear that you don't put on a Band-Aid, but rather a Band-Aid brand adhesive strip. Or you don't tighten your shoe with Velcro, but rather do it with a Velcro brand hook and loop. And you don't Google information or Xerox a document. Instead, you use a Google search engine or a Xerox photocopy machine. Thus, there is an effort to have consumers understand the source identification function by using the term as an adjective to describe the source of the product. Firms start to worry about genericide when their brand names are used by consumers as a noun or a verb. So I will probably show you a humorous video released by lawyers for Velcro that makes the point. I'll do it either in class or with a link on Canvas. So here's an old ad by Xerox that explains why the company doesn't want you to use the term as a noun or a verb. The title makes it clear. When you use Xerox the way you use aspirin, we get a headache. I'll just complete this discussion with a personal story. When I was really young, about 6 or 7, my mom's parents lived in another city and would come to visit now and then. When they did, we would sometimes go out to dinner, and at dessert the waiter would ask if someone wanted coffee. My grandfather always said he would have a cup of Sanka. I actually had no idea what that meant. It turns out that Sanka was one of the first major brands of decaffeinated coffee, and so the name became widely associated with decaf. So when my grandfather asked for Sanka, he meant that he wanted decaffeinated coffee, no matter who made it. A few years later, there was a TV show called Marcus Welby, MD, that had a trusted country doctor played by the actor Robert Young. Well, I remember this somewhat annoying ad with Robert Young at a restaurant. The waiter asked him about coffee, just like my grandfather, and his response was, "I'll have Sanka brand decaffeinated coffee." I have to tell you that Robert Young's intonation made it sound ridiculous, but it also was memorable. So much so that I can still mentally visualize it today. And the ad made it clear that this trusted man didn't want just any kind of decaf, but it had to be decaf from Sanka. Case closed. Okay, that about does it for cancellations. The bottom line is that in most circumstances, a mark becomes incontestable after 5 years, meaning that if you don't raise an objection about the registration within 5 years, you can no longer contest it. One of the exceptions to incontestability is that you can always petition to cancel based on genericism, even after 5 years. The same used to be true with disparaging or scandalous marks, but as I mentioned, those claims now face significant First Amendment hurdles. Well, there you go. That's a pretty thorough introduction to trademarks and registration. We'll next address likelihood of confusion, which is the standard for registration and infringement. I also want to touch on dilution. This is a topic I might not even bring up, except that it has some relevance to the use of trademarks with domain names. In addition, we're going to look at some of the trademark problems that can arise in international markets and how you might deal with them. Well, with that, I'm going to say goodbye and thanks for joining me here today.